By 10:17 that morning, courtroom 4B had gone so quiet that the old ceiling vent above the jury box sounded louder than the lawyers. Judge Elena Mercer had just denied the defense's third request to postpone the hearing when Ethan Voss, 27 years old, Navy suit, silver watch, senator's son, leaned forward at counsel table and said the one sentence that finally stripped the room of all pretense. "You don't want to do this to my family." It was the kind of line spoiled men mistake for leverage, low enough to sound deniable, sharp enough to land as a threat. Mercer looked over the rim of her glasses and said nothing for 2 full seconds. Then Ethan made the mistake that changed everything. He added louder this time, with half a smirk still hanging on his face, "My father can make this very difficult for you." The court reporter stopped typing. A bailiff near the rail turned his head. The prosecutor froze with one hand still resting on a yellow legal pad. And in the back row, where 2 local reporters had been whispering about whether the senator himself would appear, every eye went to the bench. Mercer didn't flinch. She didn't raise her voice. She simply pressed the microphone button and said, "Let the record reflect that the defendant has just issued what appears to be a direct threat toward this court." What happened next stunned everyone in that room, because by then this case was no longer about a reckless young man who thought his last name could outrun a bad night. It was about something bigger, uglier, and far more dangerous. A months-long effort to bend police procedure, buy silence, intimidate witnesses, and test whether the machinery of justice would break under political pressure. That line Ethan Voss threw at the judge was not the beginning of the story. It was the moment the story stopped pretending to be small. To understand why the room changed when he said it, you have to go back to 1:12 a.m. On August 14, 2025, at the corner of Fayetteville and Davie in downtown Raleigh, 3 blocks from the Hawthorne Hotel, where Senator Daniel Voss had just finished a donor event for what was supposed to be a clean re-election cycle. The rain had come down hard for less than 10 minutes and left the pavement shining black under the streetlights. A rideshare driver named Miguel Santos, 42, father of 2, was taking his last fare of the night across downtown in a gray Toyota Camry. In the back seat was Tiana Brooks, 31, a neonatal nurse getting off a double shift. The light turned green. Miguel moved forward. A black Cadillac Escalade came through the red at what crash reconstruction would later estimate was between 68 and 72 miles an hour. The impact spun the Camry across 2 lanes and shoved it hard enough into a traffic signal pole to shear the passenger side mirror clean off. Airbags fired. Glass went everywhere. Tiana fractured her wrist, split her forehead, and spent the next 6 hours in the emergency department. Miguel took the worst of it: 3 broken ribs, a shattered tibial plateau, and a punctured lung. The Escalade did not stop. That should have made the case simple. Hit and run with serious bodily injury. Downtown intersection. Multiple cameras. Injured victims. End of story. It wasn't, because within 19 minutes, before detectives had even finished photographing the debris field, things started happening around the scene that didn't fit. A uniformed officer logged a call from the office of the deputy police chief asking for an immediate update on whether the vehicle had been identified. A second call came from a private number later linked to Charles Bream, a defense attorney known in Raleigh for representing donors, developers, and the kind of men who never expected to hear the word no. Then, at 1:37 a.m., a parking garage camera on Morgan Street captured Ethan Voss stepping out of the driver's side of a black Escalade with front-end damage and no front plate bracket. He was not alone. With him was Nolan Pike, his father's chief of staff. And Pike's first words on the muted security feed, later enhanced and transcribed by investigators, were not "Are you okay?" or "Call an ambulance." They were, "Phone right now. If you appreciate stories where power finally meets consequences, stay with me, because that little detail was where this stopped looking like panic and started looking like a system." By sunrise, Ethan's first version of events was already in motion. He had not been driving. The SUV had been borrowed. Then it had been misplaced. Then a valet might have had access. The story shifted every time someone asked a different question. but facts have a way of outlasting improvisation. The Escalade was registered to Hawthorne Strategies, a consulting firm used by the Voss campaign for event logistics. There was no valet ticket, no theft report, no sign of forced entry, and the hotel's curbside camera, after technicians pulled a damaged backup file from the local server, showed Ethan himself taking the keys from a security tray at 12:48 a.m., one bourbon glass still in his left hand. That alone would have been enough to put real weight on the case. But the problem was never just the crash. The problem was what they did after it. At 9:14 the next morning, while Miguel Santos was still heavily medicated and trying to understand why his knee had been held together with plates and screws, a woman named Mara Klein walked into his hospital room carrying a leather folio and a voice so calm it sounded rehearsed. She introduced herself as a family liaison, not a lawyer, not an insurance adjuster, not a campaign representative, a family liaison. She offered to take the stress out of this. The number in the folder was $200,000, medical costs covered, physical therapy support, vehicle replacement, a confidentiality agreement, no interviews, no public statements, no speculation about who had been driving. Miguel's wife, Elena Santos, asked the only question that mattered. "Who are you working for?" Klein smiled and said, "People who want to help." Miguel refused to sign. That decision cost him months of quiet. 2 days later, Tiana Brooks received 3 anonymous messages from an encrypted number referencing her work schedule at WakeMed and the color of the bicycle she kept outside her apartment. No explicit threat, just enough detail to tell her she was visible. A week after that, Miguel's younger daughter's school pickup time was mentioned by a man who claimed he was checking in on the family. None of it was theatrical. That was the point. Real intimidation almost never is. The case went before Judge Elena Mercer on September 3rd for the first major hearing. Mercer had spent 12 years as a prosecutor before taking the bench. She was known for 2 things that made political families nervous: a clean record and a refusal to be charmed. Ethan appeared in a tailored charcoal suit and entered with the lazy confidence of a man who had spent his entire life watching rules become optional around powerful people. He stood while his lawyer argued for limited travel, broad communication privileges, and private treatment in lieu of aggressive pre-trial conditions. Bream described his client as a young man under extraordinary public scrutiny. Mercer looked down at the file, then up at Ethan. "A man left a family bleeding at an intersection," she said. "The scrutiny is not the tragedy." She ordered him to surrender his passport, prohibited all indirect contact with witnesses, barred use of encrypted messaging apps, and warned him on the record that any attempt to influence testimony would result in immediate remand. Ethan nodded like someone humoring bad service. 36 hours later, a burner phone purchased at a Durham gas station pinged twice within 600 feet of Miguel Santos's apartment building. The store receipt had been paid with cash. The store's camera showed a campaign volunteer buying the device. What tied it back to Ethan was sloppier. The phone connected for 11 seconds to a home Wi-Fi network at a townhouse leased to Nolan Pike. This was when investigators stopped treating the matter as a wealthy family scrambling to contain scandal and started treating it as coordinated obstruction. Subpoenas widened, bank records widened with them. Over the next 8 weeks, prosecutors and state investigators traced $84,600 in campaign expenditures coded as security consulting to a private intelligence firm called Halcyon Risk Group. Halcyon was not licensed to practice law. It was not hired for polling. It specialized in opposition research, digital tracing, and discrete fieldwork. The invoices mentioned reputation mitigation and witness background verification. One invoice, dated August 18th, included a line item that made Assistant District Attorney Dana Kim stop cold. Residential pattern report. Mercer, E., not Ethan, not Miguel, Mercer, the judge. That was when the story stopped being ordinary. Kim didn't go public. Mercer didn't grandstand. They did the harder thing. They built the record. Internal Affairs opened a quiet review after a tow yard manager reported that someone from the police command staff had informally asked whether the Escalade could be released before a forensic search warrant was executed. A digital analyst recovered deleted location data from Ethan's old iPad because he had disabled sync on his phone but forgotten the tablet he used at his condo. A campaign accountant facing her own exposure for filing false expense descriptions agreed to cooperate. And then investigators found the document that changed the entire case. It was not hidden in some dramatic offshore account or buried behind military-grade encryption. It was sitting inside a compressed cloud backup folder under the blandest name imaginable, Event Wrap Q3. Inside that folder was a spreadsheet, tabs color-coded, names down the left side, notes across the top, witness, pressure point, offer range, escalation path. Miguel Santos was listed as financially strained, high medical vulnerability. Tiana Brooks was profession sensitive, avoid direct contact. A local reporter who had called too many times was marked friendly editor. Under a final tab labeled exposure risk sat one line that explained why the state changed its strategy. Mercer, family perimeter unknown, acquire schedule. That was not clumsy panic anymore. That was intent. Organized, measured intent. If cases like this make you think, let me know in the comments, because what followed was one of the clearest examples of how arrogance turns a survivable scandal into a career-ending disaster. On January 12, 2026, a Wake County grand jury returned a superseding indictment. Ethan Voss was charged not only with felony hit-and-run causing serious bodily injury, but also conspiracy to obstruct justice, witness intimidation, and criminal contempt tied to violations of the no-contact order. Nolan Pike was charged separately. Halcyon's lead contractor flipped within 48 hours. Senator Daniel Voss appeared on courthouse steps that afternoon and called the indictment an overreach driven by politics. He said his son would be exonerated. He said his staff had acted independently if mistakes were made. He said the family had faith in the process. But faith was not what the courtroom saw. What the courtroom saw, hearing after hearing, was Ethan Voss getting smaller each time evidence got more specific, not humbler, smaller. The swagger had nowhere to go once timestamps started landing, once metadata started speaking, once the state could put a witness, a device, a payment, and a command in the same hour. And at the center of it all stood Dana Kim, methodical to the point of cruelty if you were on the receiving end. She never overplayed a reveal. She never raised her voice unless she needed the court reporter to capture a precise word. She just kept stacking documents until the defense was no longer fighting allegations. It was fighting math. The March evidentiary hearing was where the floor really shifted. Kim called a forensic examiner named Roland Beck, who testified that Ethan's iPad backup contained fragments of deleted signal notifications mirrored to the device before the messages were erased on the phone. Defense counsel objected. Mercer overruled. Beck then read from the recovery log. Make sure Santos understands he won't be a hero when bills hit. Brooks is shaky. Keep pressure indirect. And then the one that made even veteran court deputies look up. If Mercer thinks a robe makes her untouchable, remind her robes don't come with gates. Bream was on his feet immediately, out of context, unauthenticated, prejudicial. Mercer asked Beck one question. Was that fragment associated with the defendant's device credentials? Yes, Your Honor. Was it recovered using a standard forensic extraction process? Yes, Your Honor. She looked at Bream. Overruled. That single exchange changed the emotional temperature of the case. Until then, Ethan had been reckless, insulated, and probably criminal. After that, he looked exactly like what the state had been carefully describing for months. A man raised to believe institutions existed to absorb his impulses. The hearing recessed at 11:42 a.m. When it resumed, Kim introduced Exhibit 42, the Halcyon spreadsheet, and walked the court line by line through how witnesses had been categorized, priced, and approached. Then she produced the payment trail, campaign funds routed through Hawthorne Strategies, then through a subcontractor in Virginia, then to Halcyon. Money, movement, motive. It was devastating. Defense tried one last pivot. They argued Ethan was immature, not strategic, reckless, not conspiratorial, surrounded by older operatives making decisions he barely understood. Then Kim played the garage audio. It had been captured by a security microphone so old the sound came in with a metallic hum underneath, but the voice was clear enough. "Call my father before they test anything." Then, after a pause, Ethan again. "No one in that room is going to touch me." That was the center of gravity, the point from which everything before it snapped into focus, because the case had never really been about whether a privileged defendant made a terrible choice. Those happen every day. The real question was, what happened after he believed the system belonged to him? By the time June 3rd arrived, the hearing that began with Ethan threatening the judge was already carrying the weight of months of documented contempt. The defense had hoped for delay. They wanted time to challenge the digital chain, time to separate Ethan from Pike, time for public interest to cool. They got none of it. Mercer took the bench at 9 a.m. sharp. Daniel Voss sat in the front row in a dark suit that looked expensive in the most careful possible way. He was flanked by two lawyers not formally appearing in the case and a press aide who had stopped making eye contact with anyone. Ethan walked in 10 minutes later and still somehow looked annoyed, as if the inconvenience of accountability remained the true offense. Kim began with a short procedural argument on bond revocation. Ethan had violated release conditions repeatedly. He had participated in ongoing witness pressure. He had demonstrated contempt for the court's authority. She asked for immediate remand pending trial. Bream rose and launched into the usual language of prosecutorial excess, selective interpretation, and inflammatory framing. He said the state was trying to criminalize family panic. He said his client had been emotionally overwhelmed. He said the threatening message fragments were ambiguous. Mercer listened without interruption. Then she denied the continuance request. Then Ethan leaned forward. Then he made his threat. The courtroom was still absorbing those words when Mercer turned slightly toward the clerk and said, "Bring me the sealed filing from this morning." That was the moment the room changed, because there had, in fact, been a filing that morning. Submitted at 8:43 a.m. under seal by the state with supporting affidavits from the SBI and U.S. Attorney's Office. Mercer broke the seal right there from the bench. The filing alleged that less than 48 hours earlier, investigators had recovered a second phone from a storage locker rented under the name of a campus friend of Ethan's. On that phone were photographs of Judge Mercer's home, timestamps showing repeated drive-bys, and one draft message never sent but saved in notes. Everybody has a family, even judges. No one in courtroom 4B moved. Mercer read the line into the record herself. You could hear someone in the gallery inhale. Daniel Voss half stood, then sat back down when his own counsel pulled at his sleeve. Bream tried to speak. Mercer cut him off with the kind of calm that lands harder than shouting ever could. "Counsel, your client has now threatened this court in person after months of documented witness interference and after the recovery of material consistent with surveillance of a judicial officer. You will sit down." He sat. Mercer then revoked bond immediately, not at the end of argument, not after lunch, right there. "Mr. Voss is remanded into custody pending trial." Ethan looked genuinely stunned for the first time in the entire case. He turned toward his father. Daniel Voss did not move. The bailiff stepped in with professional speed, one at the shoulder, one at the wrist, not rough, just final. Ethan jerked once and said, "This is insane." Mercer answered him with the line that would be replayed on every local broadcast that night. "No, Mr. Voss, this is the point at which consequence finally arrives." Then, as if the courtroom had not already taken enough damage for one morning, Kim informed the bench that federal agents were executing related warrants on campaign offices and halcyon personnel as she spoke. That was what shocked the entire court. Not the raised voice, not the senator's name, the scale. What looked like one arrogant sun melting down in front of a judge was, in real time, becoming a corruption case with federal edges. If you believe no one is above accountability, stay with me because the final collapse was even more revealing than the threat. Trial began 7 weeks later. Without the shield of pre-trial freedom, without the constant choreography of handlers and back-channel pressure, Ethan's defense lost what little coherence it had left. Pike, facing substantial time and unable to explain away the financial trail, pleaded out and testified. The Halcyon contractor testified. The campaign accountant testified. Tiana Brooks testified with the kind of composure that makes juries listen harder, not less. Miguel Santos took the stand on a cane and described not just the crash, but what came after. The hospital offer, the anonymous contacts, the feeling of realizing his injury had become someone else's inconvenience. And then there was the victim impact statement at sentencing. Miguel did not ask for sympathy. He did something more dangerous. He made the damage measurable. He spoke about missing 4 months of income, about his daughter learning how to tie his work boots because he couldn't bend, about hearing men in suits discuss his silence as if it were an asset class, about teaching his children that laws mattered, then being forced to watch powerful adults test that lesson in public. "I got hit by an SUV one time," he said. "I got hit by entitlement for 10 months. Even Ethan stopped looking at the gallery when that line landed. The jury convicted on the major counts. Hit and run causing serious bodily injury, conspiracy to obstruct justice, witness intimidation, criminal contempt. Acquittal on one narrower financial count did nothing to soften the outcome. The pattern was intact. The intent was intact. The arrogance was now a matter of record. On August 28, 2026, Judge Mercer sentenced Ethan Voss to 11 to 14 years in state custody with consecutive terms on the intimidation and obstruction counts. She ordered restitution to both victims, referred related campaign expenditures for additional election law review, and recommended the preservation of all digital evidence for parallel federal proceedings. Daniel Voss resigned as chair of the Senate Transportation Appropriations Committee 2 days later. He denied wrongdoing. He called the prosecution vindictive. 3 of his longtime donors quietly disappeared from his finance reports before the month ended. His chief of staff was already cooperating. His private security consultant was under indictment. The machine had not just failed to protect the family, it had documented them. That is what makes cases like this matter, not the spectacle, not the headline, not even the irony of a rich defendant learning what a holding cell sounds like at the end of a long day in court. What matters is the exposure. A crash can be an accident, a lie can be panic, a phone call can be fear. But when the records line up, when the money lines up, when the witness list, the surveillance photos, the burner phone pings, the pressure campaign, and the courthouse threat all point in the same direction, you are no longer looking at bad judgment. You are looking at belief, a belief that status can convert institutions into servants. And every now and then, a courtroom reminds the country that it cannot. The most haunting part of the whole story was not the threat Ethan Voss made to the judge. Men like him make threats all the time, usually in private, usually through other people, usually with enough distance to keep their hands looking clean. The haunting part was his surprise. He really did not think the words would have consequences. Not immediate ones, not public ones, not in a room full of witnesses, on a record that would outlive every press statement his father's office could draft. He thought the robe would bend. It didn't. By the end, the image people remembered was not the senator entering the courthouse or the camera flashes, or even the bailiffs stepping in after bond was revoked. It was Judge Mercer, hands folded, voice level, reading that saved note into the microphone while the room understood all at once just how far the case had spread. Everybody has a family, even judges. That line was supposed to frighten the court into caution. Instead, it became the sentence that exposed the whole operation. A threat intended to create silence ended up creating a record, and once it was on the record, the thing powerful people fear most finally entered the room. Not anger, not scandal, proof.